right, well, good afternoon, everybody. We move now to panel number 3 on defining relevant markets and establishing market power in cases involving multi-sided markets. My name is Daniel Francis. I'm senior counsel in the Bureau of Competition at the FTC, and it's now my pleasure to introduce our panel. So introducing folks very briefly in the order in which they'll be speaking. Michael Salinger is the Jacqueline and Arthur Barr Professor of Management and Economics at Boston University and a senior academic advisor at Charles River. Tasnim Chipti, here on my right, is the founder and managing principal of Matrix Economics. Joseph Farrell is a professor of economics at UC Berkeley, and he's a partner at Bates White. Eric Citron is a partner at Goldstein & Russell. Darren Tucker is a partner and the co-head of the antitrust group at Vinson & Elkins. And Joanna Smith is vice president and economist in the competition practice of Charles River. So the way we're going to proceed is each of our panelists will give a short affirmative presentation for between 5 and 10 minutes, and then we'll have some Q&A. So with no further ado, we start with Michael Salinger.
Well, thank you. Economists don't like market definition that much. It's kind of ironic. And they don't like it because it requires drawing this sharp distinction between being entirely in, being entirely out, whereas in reality, there's a range of substitutes. But I think in evaluating the antitrust allegations against companies in these platform businesses, the market definition exercise is actually a quite important one, and it's important to be clear who the companies are competing with on each side of the market. So we had a long discussion today about what is a two-sided market or a multi-sided market and what isn't. But roughly, if you're a multi-sided market, you have multiple sets of customers that you are competing for. And it's important when you do this that you not do what often happens in antitrust markets, which is you take a company and you say, okay, what are the companies that are most like that company, and that's necessarily the closest competition. Because if you do that, you're going to miss an essential part of the competition. So the best example of this is with respect to the allegations, considering the allegations against Google, where there's a temptation to say, okay, well, Bing is what looks most like Google, and maybe Yahoo looks a little bit like Google, and no one else looks very much like Google, and so that's the relevant market. And if you do that, you miss a huge amount of the competition that a company like Google faces. So for example, if you consider shopping search and ask the question, who's the competition to Google in shopping search? It's not Bing, it's Amazon. And if you evaluate the allegations about Google shopping without recognizing the competitive constraint from Amazon, then you're missing the most important competitive constraint. And similarly, if you focus on the companies that just look like the company that you're evaluating, and you say, okay, we're going to look at Bing, and it's a general search engine, you make the mistake of thinking that the relevant market is for general search. So there's no such thing as a general search. Every search has a particular intent behind it. And so the relevant markets there are for classes of search, right? And so if you're doing a travel search, Expedia is an option for doing a travel search. If you want to find out what happened in the great games involving the Boston teams last night, you can go to ESPN rather than going to a general search engine. Now, the fact that you wouldn't go to Expedia to find out whether the Patriots beat the Chiefs doesn't change the fact that Expedia is a competitive constraint for travel search. And similarly, the fact that you wouldn't book a flight on ESPN doesn't change the fact that ESPN is a competitor is a competitor on sports searches. So, it's very important when we look at these antitrust cases that we do the market analysis in a way that captures the true competitive constraints on the firms.
All right, well, thank you. We turn now to Tasnim Chipti.
Thanks very much. So I thought I would kick off by talking a bit about the court's ruling in American Express in regards to market power and the question of whether, from an economics perspective, market definition is necessary to assess market power. Okay, so let me jump to the majority's opinion. For anyone who's read the court's decision, no doubt you were struck, like I was, by the emphasis on the need to define a market. The court says in multiple places that applying the rule of reason generally requires an accurate definition of the relevant market. And in this context, there's a very long footnote. The court tries to distinguish between horizontal and vertical cases. Okay, on horizontal cases, it explains that one need not precisely define a market in horizontal cases that involve agreements among competitors not to compete in some way. But it goes on to contrast these horizontal cases with vertical restraint cases, like the anti-steering provisions used by American Express, and says that because vertical restraints often pose no risk to competition, unless the entity imposing them has market power, one has to begin with an analysis of the relevant market. Okay, so I want to pause on two aspects of what is in this decision here surrounding the need to define markets in vertical cases. The first, for me, has to do with the distinction between vertical and horizontal cases. Now, I don't think many economists would say that the distinction creates a differential need for market definition. Right? That depends on the case-specific evidence. There's nothing inherent, at least from my perspective, about the conduct that necessarily creates the need for formal market definition, but rather, given the fact that vertical restraints can often have pro-competitive justifications, one needs to do some kind of balancing in vertical cases. Okay, so I think on first read, one's left with this impression, but I think a closer read suggests that the court's not actually distinguishing between horizontal and vertical cases just generically. Rather, the court has distinguished between horizontal per se cases versus vertical cases. So I think it's not entirely clear, to me at least, what the court would say about the need for market definition in non-per se horizontal cases. That's my first observation. The second, to me, really has to do with the distinction the court made with regard to direct evidence versus indirect evidence and the need for market definition in those two circumstances. I think many economists would describe direct evidence as evidence that bypasses the need for formal market definition. Doesn't bypass the need to do the kind of work that Michael was talking about, but it certainly, I think, can, in some circumstances, bypass the need to formally define and identify what's in and what's out in some kind of bright line way. And that indirect evidence is usually what we describe as work that sort of is built on a more rigid approach towards market definition. Now, taken literally, the majority on the court here in American Express would seem to be saying that market definition is necessary for both approaches. And to me, this strikes me as odd and contrary to how we normally practice. And in fact, it's notable that the dissent, in its written opinion, expresses the opinion that market definition analyses are beside the point, they say, when there is an actual finding of anti-competitive harm. So anyway, those two things really sort of struck me. The other thing that struck me is what the issue was of market definition that the court actually raised and took on. Right? Most economists, I think, would agree that the work of market definition involves thinking about the substitution possibilities of the type that Michael was just talking about from the perspective of consumers, which in the Amex case involved two groups of consumers, merchants and cardholders, both of whom consume card services. Now, traditional market definition work would involve tackling the questions like, is a debit transaction a substitute for a credit transaction? What about cash? What about check? And so forth. These are not the issues that were debated in the American Express decision. In American Express, the work of market definition involved deciding whether to analyze American Express's anti-steering provisions in, quote, a single market, where the product is jointly consumed, jointly and simultaneously consumed, or in two complementary markets involving, on the one hand, speedy payments to merchants, and on the other, credit for shoppers. Right? The majority was of the view that in order to assess competitive effects here, one needed to describe the market as a single market as opposed to two complementary markets. Now, from my perspective, and I think probably many economists would agree, it really doesn't matter what label you attach to how you describe the nature of the competitive interactions and the competitive discipline facing the firm, as long as the economic analysis accounts for the linkages and the interdependencies. I don't necessarily see the need to define a formal market, even though here we find ourselves in a vertical case with a two-sided platform. So I guess I leave it at that. I still think it's an open question as a matter of economics about whether or not one needs to define the market.
Wonderful. Let's turn to Joe Farrell.
Thank you. So our assignment, I think, or the title of our panel is Defining Relevant Markets and Establishing Market Power in Cases Involving Multi-Sided Platforms. And I think it's useful to go back to first principles, somewhat echoing what Tasnim said, and say why, what? So first of all, establishing the opposite of market power. Why are we doing that? It's not a simple question, actually, because having market power is not an antitrust offense. So why is an enforcement agency trying to diagnose market power? It's because a syllogism that we use in antitrust is if you have no market power, then you can't unilaterally do anything bad. Anything has to be caveated a little bit, but roughly speaking, that's the syllogism. So going back to some things that I said this morning, but saying them in a little more length. Okay, so then I think the techniques for diagnosing market power ought to be techniques such that the answers to the questions you're asking help you diagnose what would happen if this firm or these firms collectively did something bad. And so you need to have some way of modeling or gauging or telling what would happen. Trying to stick with the active verbs here rather than the abstract nouns. And I think from what we've heard and from what we know, the answer depends on what's something bad. So I don't think there's an a priori way to establish or not establish market power necessarily without thinking about the what's something bad. Maybe a particular way of diagnosing it would apply to multiple kinds of hypothetical bad actions, but you can't count on it in advance, partly because there are a lot of moving pieces in multi-sided platforms. That's kind of my first observation. Second observation, a little more constructively perhaps, is, we talked this morning about some of the things that you would probably want to look at in trying to diagnose market power. And a lot of it has to do with both the strength of the complementarities and with the stickiness of one or another group of users, switching costs, single versus multi, homing, and so on. All right, and so then the second half of our title is defining relevant markets. It's strange that that came first, but again, that's the economist's perspective. So why define relevant markets? Well, one answer is because a court said so, but that's perhaps not a very interesting answer to the economists. I would say the right answer is to help illuminate market power and associated questions. Ideally, using the same techniques that we use in one-sided markets to use market definition to help diagnose market power, which is, roughly speaking, if you're small, then chances are your customers are not all that committed to you, because if your customers were all that committed to you, then there'd be more customers who are willing to go with you. And so if your customers are not all that committed to you, then if you did something bad, they would leave. Various refinements and nuances to that. You might have just a few customers who are very committed to you, and then how do you think about it? But loosely speaking, I think that's the intuition. Question, can you extend that intuition and that technique to the case of multi-sided markets? Well, maybe, but it's kind of awkward, actually, because by definition, there are different kinds of customers who differ from each other, not in how attached or mobile they are as between competing firms, but they differ from each other in the very roles that they play, and they may be very different in the roles that they play, depending on how the two-sided structure works. And so I think one thing to keep in mind is just, sure, go ahead and think about alternatives, absolutely. If that's what we mean by defining a relevant market, then go for it. If you're trying to come up with some group of products such that measuring share within that group of products or customers is going to tell you the answer to market power, I think it's going to be a lot more challenging. And I'm happy to say that there is a footnote, a short footnote in the merger guidelines that kind of makes that point in a very brief and cryptic sort of way. So 8 years ago, the division and the commission had already thought about that. So I suggest that instead of holding these hearings, you just look back at the notes from drafting the merger guidelines, because probably the answer is going to be there.
Wonderful. Eric.
Yeah, I'm going to speak pretty briefly, the hope of illuminating more during question and answer. I think from my perspective, the thing that Tasnim and Joe are saying politely is that the Amex decision is more or less economically illiterate. The Supreme Court just does not understand how economists assess market power, why they do so, what role market definition plays in that, and that's unfortunate. But when the Supreme Court was on an economically illiterate pathway 50 years, 60 years ago, antitrust scholars and students took it as their job to more or less relentlessly shame judges into understanding the economics that underlie antitrust practice. And just because the side of the aisle to which current judges tilt has changed, there's no reason why antitrust scholars should abandon the same view of what their role is in this particular legal space. Judges are not antitrust experts. This is hard for them. Justices of the Supreme Court are actually even less likely to know the antitrust economics because they have to be generalists. And what we need to do is try to teach more and more judges and justices how to do their work in ways that are productive. And I think honestly the best way to do that is to, picking up on something that Joe said, is to try to demystify the practice of market definition and market power analysis to the greatest extent possible. It's not that complicated. You just start by asking, why do I care? Why do I care if this company has market power or if these merged companies will have market power? In the merger space, it is frequently, though not always, well, are these merged companies going to be able to raise price? In the conduct space, it's often, what will happen if this company does something bad to the people on one side of the market or the other? In other spaces, market definition has or price definition has totally different purposes. A lot of the two-sided market scholarship that underlies Amex is actually just about whether you count the price on both sides of the platform for purposes of analyzing whether price exceeds marginal cost for purposes of predatory pricing analysis. That might make sense. It has nothing to do with two-sided markets or whatever. This is, in a way, it's a conceit of antitrust attorneys that antitrust is so complicated. Maybe it is, I don't know. But I don't think antitrust economists think of market power analysis and the role that it plays in any given case as being particularly mystical. And it would be easier, actually, if we just started teaching to the greatest extent possible through vehicles like the FTC and the Antitrust Division and their guidelines why it is we're engaged in these practices. So I guess what I'm saying is I don't want to relent on the Amex battle, even though it's been lost once. It's our role, I think, here to try to explain to the court how we can do better. And until we abandon the sort of mystical view of defining markets and assessing market power, we're not going to make a lot of progress.
Eric, thank you.
Do you mind if I just interrupt briefly and say, you may have noticed I haven't commented on Amex specifically, and I don't intend to. I'm partner at Bates White, and one of my partners was deeply involved, so I'm not going to say anything about the case specifically.
Great. Let's turn now to Darren.
Well, excuse me, thanks very much. I want to thank the Commission for holding these hearings, and in particular to the panel organizers for inviting me to speak here today. So Tasnim spoke a bit about the Amex decision, which of course offers some potential guidance to the courts in terms of how to look at two-sided platform markets. So let me sort of start there and share my thoughts as to what the big picture takeaways from that decision. So I think that really one of the fundamental insights from that case is that courts need to include all sides of a platform when defining markets involving two-sided platforms, except when indirect network effects and relative pricing effects are minor. As an example of that, where there's a two-sided market but minor indirect network effects, according to the court, is a traditional newspaper ads, where the indirect network effects operate in only one direction because readers tend not to like to see more advertising, all things being equal. The decision also says that plaintiffs need to demonstrate anti-competitive effects in the two-sided market as a whole. And in a direct evidence case, which the Amex case was, plaintiffs can do this in a number of different ways. They can show prices increased above a competitive level, output drop, or quality decreased due to the restraint. But all of these need to be measured in the overall market, the overall two-sided market. I don't read the decision as saying that a reduction in output is necessarily required, as some have read the decision to say. In fact, the court says repeatedly that an increase in prices combined with a showing that prices were above a competitive level in the overall market would be sufficient to establish a prima facie case. So in sum, really, I think what the key takeaway is the decision makes clear that in a two-sided market, establishing harm to just one group of participants is insufficient for a plaintiff to establish a prima facie case. So an important question raised by the decision, kind of an obvious question, but important, is what markets fall within the decision's holding? So what markets going forward will be treated as a two-sided platform market subject to Amex? So I don't think it's particularly surprising or concerning that the court really didn't flesh out the answer to that question in any detail. Leaving courts to fill in the details is really the typical approach of the Roberts Court, not only in antitrust cases, but in most other types of cases before the court. For example, in the activist antitrust decision, the court held that large unjustified payments from a patent holder to an alleged infringer could be anti-competitive without actually explaining what large meant. So it'll be the work of the lower courts and the U.S. antitrust agencies to help flesh out exactly what markets fall within the decision. But in doing so, they should avoid the temptation of reading the decision narrowly. For example, the case in Amex focused on what it called a special type of two-sided market, called a transaction market, which it called or described as having simultaneous sales. But the court's holding was not limited to that particular type of platform market. And I will say that I'm skeptical of claims that I've heard that the courts or agencies are ill-suited to identify two-sided markets. These markets are usually straightforward to identify, and enforcers can observe the degree to which the effect of a challenged practice affects each side of the market. No one can seriously dispute that credit cards are not a two-sided market, for example. And there's a number of other markets that are discussed at length in the economic literature that would seem to fall within the scope of the decision because they're two-sided markets. Shopping malls, operating systems, app stores, video game platforms, auction marketplaces, job boards, ride-sharing platforms, stock markets, ad exchanges, and so forth. Likewise, markets where buyers and sellers transact directly will generally fall outside the scope of the decision. And in my view, proper implementation of the Amex decision by the lower courts and antitrust agencies will lead to more accurate and effective antitrust enforcement. Although it didn't use the terminology, the court noted that the decision would help reduce type 1 error. In fact, it should also reduce type 2 error. Consider conduct that directly affects users on only one side of a platform, some kind of a restraint or pricing effect. Analyzing conduct on just one side could reach a false negative by ignoring harms on the other side, and a false positive by ignoring benefits on the other side. Likewise, applying the hypothetical monopolist test or critical loss analysis to a single side of a two-sided market could lead to markets being either drawn too broadly or too narrowly. There's no particular reason to believe that application of correct two-sided analysis should reduce overall antitrust enforcement levels or increase false negatives relative to reducing false positives. The dissents approach in the Amex decision would make it more difficult to attack platforms in which conduct on one side inflicts harm on the other. In other words, a false negative. For example, to go back to the Amex case, and assume instead of increasing merchant fees, as was alleged in the Amex case, what if Amex had substantially reduced merchant fees, but kept the fees above marginal cost and managed to continue its generous rewards program? So Amex loses huge amounts of money, but manages to drive some of its competitors out of business. A single-sided analysis would focus on the conduct on the merchant side, since that's where prices are being lowered. But since prices are greater than marginal cost, there'd be no basis for a Brook Group claim. A two-sided analysis, on the other hand, accounting for prices and costs on both sides, would identify this predatory behavior and avoid the error. In short, considering the effects on all platform participants is far more likely to lead to a court or regulator to understand what's really happening in the marketplace and reach the correct result. For these reasons, claims that the court's decision will give big tech companies a free pass to engage in anti-competitive conduct are off the mark. In fact, application of Amex will make some potential claims against platforms easier and some more difficult. More importantly, the goal should be to conduct the proper analysis regardless of where the results take us. To be sure, it will often be more difficult to assess price and output effects in multi-sided markets than in traditional markets, but difficult and right is superior to easy and wrong. Finally, with these hearings and its day-to-day enforcement and policy efforts, I think the FTC has real opportunity here to play a valuable leadership role in expanding and advancing two-sided market analysis with other competition enforcers. The economics of two-sided platforms is well established in the industrial organization literature. But in my experience representing U.S. companies before non-U.S. competition agencies, I've observed that exceedingly few have attempted to incorporate these insights into their enforcement and policy missions. Simply put, the notion that a platform operator might impose a restraint on one group to benefit another group is a novel concept to many regulators and enforcers outside the United States. Particularly with the attention drawn to this issue by the Amex decision, the FTC and DOJ have an opportunity to play a leadership role on the global stage in explaining when and how to define markets involving platforms, which could have the potential of improving the quality of enforcement and achieving more consistent outcomes.
Thank you, Darren. And finally, we'll turn to Joanna.
Thank you, Daniel. So I'm at a slight disadvantage here because I'm going last today, and all of my very distinguished panelists here today have made all the very brilliant comments already. On the other hand, I have a slight advantage in the sense that I've had the benefit of hearing what everyone else had to say. As an economist, I always look at both pros and cons of every issue. So I thought I would start off with sort of the key relevant, before diving into relevant markets and market power, to go back to first principles and to talk about what are the key relevant characteristics of multi-sided markets before getting to relevant markets. I think a lot of us agree that multi-sided platforms exhibit the presence of indirect network effects, meaning you have network effects across various sides of the platform, and as a result, you have interdependent demand. And the strength of the linkages in the platform for the different sides may be stronger in some platforms and weaker in others. Because of the feedbacks and the interdependencies of the different sides, the multi-sided platforms ultimately need thriving levels of customers and activities on all sides. And then profit maximization requires taking into account demands and costs of each of the sides and the interdependencies of the demands on the different sides and indirect network effects. These characteristics, I think, necessitate the need to implement economic analysis with additional considerations. Another additional characteristic that I wonder if it's that is less commonly talked about out there in, for example, decisions like Amex, is whether we need a formal economic definition of two-sided markets. I think for a period of time, a lot of people would talk about, multi-sided markets, and we see a definition of it in the Amex decision, but economists have also long known a definition that's been proposed by very respected economists like Roche and Terrell, which adds something in addition to indirect network effects, which is that, a multi-sided market is when the overall volume is dependent on the price structure in addition to the overall level of the fees charged by the platform. And so I just want to throw that out there for now for everyone to, sort of think about whether this is something that, in the analysis of multi-sided markets, it's important to have that as a key relevant characteristic. Now, with that out of the way, market definition. What is the key differences between defining relevant markets, in businesses involving multi-sided platforms as opposed to single-sided platforms? I think the traditional techniques for defining relevant antitrust markets still apply. They just need to incorporate and account for the multi-sided nature of the business. Another complication is, not all multi-sided markets are alike. There are different categories. I think we started to see categories such as transaction platforms versus non-transaction platforms that's, sort of surfaced or evolved or, been highlighted by the Amex decision. So traditionally, we will look at market definition and define it by, asking the hypothetical monopolist test, a SNP test. So where do we begin and where to end with that, right? So let me just talk through, sort of this is how I would think about it. So the test, again, identifies constraints on pricing and other business decisions to maximize profits. There is a need to identify competition on the different sides of the business, which may include other multi-sided businesses that compete for the same customer groups on the different sides, as well as single-sided or other multi-sided businesses that compete with just one of the sides. Okay? We start with identifying a multi-sided platform's distinct group of customers and the various businesses in the single-sided, multi-sided platforms that serve each groups of these customers, and their potential competitors in the multi-sided platform that may constrain their pricing or other business decisions. So far, all very similar to single-sided analysis, except we are looking at things on the different sides. A snip for one side of the customers affects the demand of the customers on the other side because of, as we talked about, the indirect network effects and the interdependent demands, which in turn has the impact on the demand of the first side of customers. And then the small increase in price on one side reduces the quantity demanded on that side as well as quantity demanded on the other sides, which in turn further reduces the quantity demanded on the first side. So there's a loop effect. Because the interdependencies across the different sides of customers, a hypothetical monopolist that only considers one side of its platform might increase price on that side and actually lowers its overall profits once the effect on the other side is accounted for. Right? I think it's important to consider all these sides because ignoring the effects on the other sides could cause one to arrive at a relevant market that is too narrowly defined. For transaction platforms, meaning a simultaneous transaction takes place and it's proportional, one on each side, one might modify the SNP test to use an overall price and output like number of transactions for all similar platforms and allowing the hypothetical monopolist to maximize profits across all sides, taking into account network externalities. I think this gets a little more complicated when we're talking about non-transactional platforms, but I think that's something that maybe we'll cover a little later on with the Q&A. Oh, well, I think I've used up my time, so I will stop at that. Thank you.
All right, Joanna, thank you. So before we move to the Q&A, I want to give our panelists an opportunity, if they want to do so, to respond to any of the affirmative presentations, if they'd like to do so.
Yeah.
Please do.
So I agree with Tasnim that if you identify effects, there must be some market in which that was relevant for antitrust purposes, and whether it was precisely the one the Department of Justice defined or not should be irrelevant. And I agree with Joe that if the reason you're defining a market is to then measure share and infer market power from a high share, that's completely right. This morning we had a lot of discussion about whether what is a two-sided market, and there's sort of one view is that, well, it's obvious, and then we try to define it, and it's and Joanna mentioned the Roche and Tirole definition, which is interesting, but it's not obvious that that's the right definition. And I'm sort of troubled by this, by the contrast between it's obvious and we can't really define it. Because of casual comments that I've heard. So I think 3 times today I've heard the assertion that Google is a 3-sided market and not a 2-sided market. And so the argument is that the websites that would like to get placement in Google's results are one side of the market. And David Evans isn't here, but I've argued with him about this before, and I think the argument he would say is, look, there are websites out there that want viewers, and there are viewers out there that want to see websites, and Google is bringing them together. And that means that the websites are a side of the market. But the problem is that when the essence of a 2-sided market is that you have 2 sets of customers that you're competing for. And Google's not competing for the websites that want to show up in its results. I mean, at some technical level, they have to agree to be to have the sites crawled, but they're competing for they're competing for people who search, and they're competing for advertisers. But the relationship with respect to the websites is much more complicated, and it's not a customer kind of relationship. And so, if we're not able to define what these markets are, there's this risk that there's going to be this casual assertion, that here's a side of the market, and by the way, if someone on this side of the market is harmed, that's customer harm. And therefore the sort of harm that the antitrust laws are concerned about. And if we do that, we're going to make some very bad decisions.
Michael, thank you. All right, we're going to turn now to a little Q&A. Let me just point out to you, there are two or three FTC folks who will be walking up and down with index cards, which is our 21st century tech-focused way of encouraging you to be interactive with our panel and ask your questions. So they'll be up and down, flag them down, send us a question, and I'll ask it. All right, so why don't we turn, while that happens, to a couple of more general questions. And I'm going to start with one for Joe and Michael, and then anyone else who wants to respond as well. And that's the foundational one. Why is it that two-sided or multi-sided platforms merit distinctive or special antitrust treatment to the extent that they do at all? So we know that intermarket externalities, whether indirect network effects or of other kinds, are pretty common throughout the economy, and it is more generally not rare that price and demand in one market will have effects on price and demand in other markets. We see this when markets are upstream or downstream or complementary of one another. Two-sided markets are obviously distinctive in that buyers don't internalize or may not internalize those effects. But is that enough to warrant sort of special antitrust rules of the kind that the court seems to signal in Amex? And if so, why? Why are two-sided markets or multi-sided markets special for antitrust purposes? And let's start with Joe.
Well, as I said, I'm not going to comment on Amex specifically. I think actually the answer to the question is they don't really merit distinctive antitrust treatment. In all cases in antitrust, I think, maybe except for naked price fixing, you want to know what's going on, what protections do customers and others have against it being harmful. That gets to this market power question. What sort of harm can be expected to result? What sort of efficiencies might arise? It's all the same questions. It's different details. But we know, and the agencies have often said, antitrust always is fact-specific. Again, perhaps except for naked price fixing. And so you're always trying to wrestle with fundamentally the same set of issues. I think what we're discussing here today is not how to categorize some markets or some businesses in a way that puts them into a different box. I think we're really discussing what are some things that you need to keep in mind in dealing with what turn out to be an awful lot of different businesses and markets in the modern economy to some extent. And so if you take it that way, then I'm not convinced that they either merit or will get distinctive antitrust treatment if the antitrust treatment can be defined not in terms of rules and boxes to check, but in terms of intelligently analyzing the fundamental questions.
Michael.
So I agree with what Joe just said. The only thing I would add is I think part of the reason that we're interested in multi-sided markets, I mean, in part it's the Amex decision, but if the Amex decision hadn't occurred, we'd still be talking about it. But the reason really isn't the multi-sidedness of it. It is that there are these very successful business platforms that have two-sided strategies, and and they're very innovative businesses. And, really the big issue with these businesses is not the two-sidedness. It's how do we do antitrust with innovation? And that's, of course, not a new issue. We've been wrestling with it for a long time. But I think that it's an issue that we haven't nailed down quite as well as how to do, how do you evaluate merger between two grocery stores. And the companies for which this is, these innovation issues are relevant is not limited to companies with two-sided platforms. I mean, you can, I guess the question, do you view Apple as being a two-sided business? There are elements of it, but but in many ways, it's designed its business differently from some of these other companies that are being talked about, and it's more one-sided in its business model.
Would anyone like to respond?
Sure, I'd actually like to add something on top, which is that I think in part, given the nature of certain businesses that involve two sides or multiple sides, the firms necessarily need to be big. So, for example, early on, Joe said, well, you might have a situation where you could say, well, this firm is small, if you were able to measure the share properly and look at it, you might say, well, this firm is small, so we can move along, nothing here to see. But the fact is that in many of the types of businesses that I think have already been described or suggested today, and that you can think about in your own world, these businesses tend to be big, and the fact is that the network effects, the need to create these platforms is not just a coincidence, it's because of the nature of the business that they're selling. So I think that perhaps means that we're not going to necessarily find small firms. Maybe newspapers, some local daily newspapers, but by and large, all of the examples even spoken here today are large firms because they, in essence, have to be.
Yeah, and can I jump in on that? I mean, of course, we're very familiar in modern antitrust with the fact that the link between size or market share and market power is not a tight link, not as tight as perhaps people used to believe. And I think this is an example of that. So it might be that in a particular market with strong network effects, you've got to be big, and that might be true with or without effective market power.
That's right.
I think that's right. Can be taken too far, but basically right.
So speaking of taking things too far, let me ask you about the kind of more kind of complicated or troubling side of the concept of two-sidedness as a zone of special pleading in antitrust, to the extent that that's what we're going to see as a legal matter, even if as an economic matter that might not be intuitive. And I'm going to start here with Eric and Tasnim. My question is, what do you see as the principal risks of misuse of this concept? So we now have a Supreme Court decision out there, right, that's very sort of popular and exciting, and we're all talking about it and engaging in sort of exegesis of the text. But one thing that is pretty clear is the Supreme Court is telling us that there is something different about antitrust in these markets, in these contexts. And it's going to be for lower courts and for agencies, and to some extent for the bar, to operationalize that and to figure out how far this distinctive treatment, this special set of rules, is going to extend. So my question is this: do you worry about misuse of the concept of two-sidedness? Do you have some concerns that it'll be inappropriately extended or deployed by courts or enforcers or the bar? And if so, what warnings would you want to give against that kind of misuse? Let's start with Tasnim.
Okay, so I guess one of the things that that worries me about courts thinking about multi-sided markets, it was said earlier, I think Darren said it, that it's relatively easy. I actually don't think it's that easy, because you have economists struggling with it and struggling to explain it to each other, let alone to non-economists. I'll give you for example, something that I think is a difficult question, and I don't think there's a clear answer, and I certainly don't think there's a one answer fits all. and that is the issue of price structure. Okay, there was a lot of discussion, even in the American Express decision, about the net price, and let's look at the all-in price on both sides of the platform. Well, so does price structure matter? What would we think about a setting in which a firm raised prices on one side and essentially gave it all to the other side? Do we not care about the different experiences and the welfare consequences for different segments of consumer groups? Is the economic consequence of the net price the same as across all different sort of paths by which that net price came to be? I think that's a really hard question to answer, and I do worry a little bit that one of the sort of easy ways to take the American Express decision is to look at the net price, and I think that could be a mistake. I think that the decision is very open, and I think Darren mentioned that this was perhaps sort of the way it should be, and perhaps the way all Supreme Court decisions go. But reading it as an economist, I found little guidance in how to weigh the benefits to one group to the harm to the other, or perhaps to weigh externalities to consumers that were on neither side of the platform that might also be affected. So I think there was that the decision doesn't contain a clear guideline on how to proceed, and in many ways, I suppose that's a good thing. And then finally, I just close it with the mantra that I started with, which is that I sure hope sort of lawyers and courts don't look at this decision and think that, oh, multi-sided platform must define a market. It kind of, maybe yes, maybe no. It kind of depends on whether that's a useful exercise.
Thank you. Eric?
So I tend to be a somewhat Pollyannish person, so I'd like to give the hopeful answer, but here's the real one. We have an adversarial system. So what's going to happen is that defendants are going to say, I have a two-sided market defense. They're going to put on an economic expert that they are allowed to pay for, who will say, this is a two-sided market, so it is impossible that this person has market power or could violate the antitrust laws. And judges who have no economic training are then going to try to analyze that defense. And that is a disaster. Okay, so I think almost all uses of the Amex decision are likely to be mixed uses for reasons that I think Joe was saying, probably in less incendiary terms and a better accent, which is to say, what we're trying to do is intelligently answer a pretty straightforward antitrust question. And if the answer is something, and if the question is of the kind in Amex, then the proper use of the Amex decision is pretty straightforward. The prosecution is saying this company has the power to make merchants do what they want, and Amex is trying to defend that proposition by saying, well, no, because there are consequences on the other side of our business model or our market or our platform or something that are going to somehow constrain what I'm able to make merchants do. And if that's true, if Amex can show that, or if the prosecution can't show it, then great. We've identified the correct question and the right way to answer it. If it devolves into a kind of abstract question about the two-sidedness or eight-sidedness of Amex or whatever, then it will be pointless and very likely to confuse. And I just think the more likely thing is unfortunately the latter rather than the former. And so the thing that we ought to keep trying to encourage courts to do is to do something more like the former. Correctly identify the question, understand why we care about market power or market definition in this context, and then try to tackle the question in the least mystical and most straightforward way that you can.
Eric, thank you. Would anyone else like to take up the theme of misuse of the concept of two-sidedness? I think Joanna.
I would just like to add a small comment to something that Tasnim had said earlier. I agree that it's an important question. It's important to consider whether structure is important in addition to the net price level. But I do want to point out that, it's important to not make it too important as well, because at the same time as Amex had recognized, American Express versus other payment cards, decided to charge to have a different allocation and split, between the two sides. And that's pro-competitive, it's innovation. And so trying to decide sort of what should be the right allocation, one or the other, I think there could be a danger in I think pointing to something that, maybe is allocated differently and, calling that, potentially harmful.
So one of the themes that has emerged from a number of the comments is the space between antitrust law and antitrust economics, which we may confront more often than we would like in this space in particular. So I'd like to ask, to what extent the Supreme Court was successful in reflecting in legal terms the economic scholarship on which it was relying. And I'm going to start here with Tasnim again and Michael. So in Amex, the court purported to rely quite heavily on the Filostrucci paper dealing with market power and market definition in two-sided markets. But when the court came to explain or express in legal reasoning the grounds for its conclusion, it emphasized two or three things quite distinctively. So one was the joint and simultaneous nature of activity in the credit card market on the cardholder side on the one hand and the merchant side on the other, which strikes me at least as pretty consistent with the Filostrucci discussion of transactional markets. The court also emphasized, point two, the significant bidirectional externalities, which of course we'd expect. And point three, the prominence or preeminence of competition at the inter-platform level among credit card providers. So recognizing that some of those factors are pretty common, approaching ubiquitous in some cases, was the court right? Did the court do a good job here of expressing in, legal reasoning terms that us lawyers without a background in economics can go out and apply the economic work on which it was relying? Or has the court set out a set of factors that don't accurately capture the economic scholarship on which it's relying? Why don't we start with Tasnim?
Sure, I would say in part, yes, it did a great job, and in fact, surprisingly transparent discussion of the business models and the economics, and in part, no, for some of the reasons we've already talked about, at least in my view. But one of the things that I think is missing from the list of things that you just went through is the fact that in this particular case, there was the nature of the conduct, which was at the heart of why I think the court thought about the transaction market. It was the nature, so for example, if you had a two-sided platform that was accused to have done something nefarious in some place in its supply chain, I don't know necessarily that we'd be focusing on this. It was the nature of the conduct specifically worked at the nexus of the bringing together of the two sides of the platform. And so I think that the literature actually that the court cited talks about this quite a bit, and it is one of the themes. I don't think the decision uses the same language as the literature, so perhaps it got left off the list, but I think that is something that the court identified well and appropriately. And so I do think that in many ways they accurately describe the literature. I will say, though, that on the subject of market definition, the very papers, the literature that the court cites raises a concern about getting stuck unnecessarily in dealing with the complexities of two-sided platforms, and the concern that to do it rigidly and mechanistically could lead to sort of a distraction from the important issues. So in that sense, I don't think that the court hit the nail right on the head.
So just to follow up very briefly before we turn to Michael, I think some of that literature, even when talking about credit card markets, emphasizes the difference between the transaction level, where activity is joint and simultaneous, and the membership level, where it really isn't, right? So the services that a credit card company provides to a cardholder, rewards and whatever else, are neither joint nor simultaneous with what it provides to merchants. Do you think it's possible that the approach to market definition we've seen the court take here in the context, as you say, of transactional conduct might actually lead to the opposite conclusion in antitrust cases where the conduct in question is about membership, is about dealing with customers in a way where activity is not joint and simultaneous, even though we're in the credit card space?
Oh, it would depend, I would think, on the nature of the conduct and then tracing through the role of that interconnectedness. You know, so I don't think we can answer the question without recognizing the two-sided platform, but I don't know unambiguously in a hypothetical whether it would necessarily go in one way or the other.
That makes sense. Michael?
So the court got right that when you're looking at a credit card market, you can't just look at the merchant fee and say, oh, the merchant fee is high, therefore there's an anti-competitive effect, and that you've got to look at the other side of the market and consider consider the incentives that the credit card company is giving. It got wrong, at least as I read it, that it seemed to suggest, well, all you have to do, what you should be looking at is the combined price, the merchant discount, but minus the incentives. But if you take the Rocher and Terrell article that Joanna talked about, she said, it says it's only a two-sided market if how you divide up that total price matters. And this is something that Justice Breyer pointed out in his dissent. And then I think the question is, even though the court got it right that you have to look at both sides of the market, the question is, was market definition the stage where you should do that, or would you, when you're evaluating conduct like a no steering clause, do you evaluate that and take account of the two sides of the market at the second stage where the company puts forward its justification for why it thinks its behavior is reasonable?
Would anyone else like to respond? All right, so let's bring Joe and Joanna back in with a question that touches on some of the things that we've heard raising their heads a few times. So a number of folks have referred to combined price, overall price, net price, price structure. There are a series of ways of talking about price and output across a platform as a whole. And I'd love to hear what you think about how we can usefully measure overall price or overall output in non-transactional multi-sided contexts. So when activity isn't joint and simultaneous or isn't even directly proportional on the two sides, it can be very hard to tell, at least in the abstract, sort of whether overall output in some relevant sense has increased or decreased. So we'll see that, for example, if price and output change on one side and change perhaps in the other way on the other, Amex encourages us, at least in the course of proving anti-competitive effects, to try to answer the question. It might not require us to do this, but at least encourages us to do so, to answer the question of whether overall output has been reduced or overall quality adjusted price has been increased. But how can we do that in cases where we've got a non-transactional platform and activities aren't directly commensurate with one another? Let's start with Joe.
Well, I think this is a hard question. So in the traditional single-sided, nothing subtle type context, quantity is often a good measure for consumer welfare. But one of the conditions for that, which is not always true, is that there's no price discrimination. So the fact that the marginal customers are getting a good deal and caused to become actual customers rather than potential customers is a good indication of what's happening to the other customers. When there's price discrimination, then you can't necessarily make that leap, and you have to worry about that. And I think you could say that in a multi-sided context with different prices to the different sides, as you'd normally expect, that is kind of like price discrimination from the point of view of that proxy for customer welfare. I would also say the extent to which we, particularly in conduct cases, really set out to evaluate customer welfare. In a way, it's supposed to be the focus, but in a way not. I mean, it's really more about whether you're getting in the way of somebody potentially making a better offer than you're making. And how good an offer you're making compared to some other benchmark is not exactly, I think, in all cases, the right focus. So I think you raise a good and difficult question. I think it is present in more traditional contexts, although in a slightly different form. And I also think, if we focus on the competitive process, I'm not saying you won't get to that question, but it's not as obvious that it's central as you might think.
Joe, thank you. Joanna.
I think this is a very difficult question, but a very good one. So in transaction markets, such as in Amex, you have one transaction on one side, one transaction on the other simultaneously. We see other platforms like this, like, perhaps ride sharing like Uber, a ride, is the transaction. In the non-transaction platforms, they don't equal both sides, and even more importantly, they are not measured by the same unit of measure, right? So that makes it tricky. So examples include content advertising models or social networking media. Okay, so when they are not directly proportional or the same transactions, then in content advertising model, for example, on the one side, we could observe 100 subscribers and each paid $1. On the other side, we might observe 10 advertisers and each paid $10. Then what do we do with them, right? It's not possible to measure an overall price or output because such measurements are just not meaningful. So on the one side, the unit of measure for output is number of articles of relevant information for the subscribers. On the other side, it could be and that's what the subscribers are paying for. On the other side, the unit of measure could be number of eyeballs or number of click-throughs in your advertising model, and that's what the advertisers are paying for. Again, that doesn't help in terms of conceptually finding that aggregate price. So we have a problem, and I think there are a couple of ways to tackle this that we could consider and maybe begin to think about. So Amex recognizes that in the decision, my reading of it is that it specifically is applicable to transaction platforms, and other multi-sided platforms may be different. And in situations when we have non-transaction platforms, since our antitrust laws are implemented with a consumer welfare standard, one possibility is to treat each side as separate groups of consumers and evaluate the effect of a merger or conduct on each side, taking into account the cross-platform network effects without trying to aggregate and put them together and calling in this one thing or unit of measure. So, for example, in assessing whether a proposed merger between two social networking platforms harm consumers, we assess whether consumers on each side would end up paying higher, quality-adjusted prices. Okay? Now, but implementing this analysis, I recognize that there are a few things that would be tricky and would require extra care when implementing. One is that such analysis must take into account, I think, the increase in value from the customers from a greater network effects resulting from a greater network, and finding a way to measure that and incorporating it into a quality-adjusted price that the consumers face. Second, cost efficiencies from a merger like that and how to allocate them across sides. And then thirdly, a really difficult question is how should the welfare of the different sides of customers be weighed when we reach a result in which one side is better off while another side is worse off?
Wonderful.
Can
And please do, Eric.
I want to try something, which is going to be a live experiment in the demystification of the question. Because this is not something where I understand the economics really well. But I'll give you the following example. The reason that quantity is a really good measure of consumer welfare or the like in the traditional manufacturing market for widgets or whatever is that if the person who makes the widgets puts more widgets out there in the market, that's typically good for consumers. It will drive the price down. It will mean that more transactions can happen. The marginal consumer is able to afford widgets when they weren't before or the like. But Amex or credit card companies, they don't manufacture transactions and offer them for sale. Amex is essentially wants all the transactions to go across Amex's platform. They aren't increasing the queue of transactions or the like. But if you look at a more traditional relationship that Amex does have, you do see the normal relationship between price and quantity. Merchant acceptance of Amex is constrained by how much Amex asks merchants to pay. And so there's a large chunk of people who don't take American Express, but do take Visa and MasterCard because the price is higher there. And that's a real example where you see that the higher prices are driving quantity down. And that if Amex wanted to have more merchants who took American Express, it would have to lower prices as a result. And what you see there is that output really is constrained in meaningful ways by Amex's practices, but you can't get that by trying to see how many transactions Amex has in total, because Amex, like I said, isn't manufacturing transactions. It's not trying to create transactions. It's just trying to capture as much of GDP as it can in Amex transactions rather than, dollar transactions or check transactions or the like. And so, I think there are times when focus on quantity makes sense, but it's not going to be in these circumstances where, it's not something that the company actually makes or produces.
Would anyone care to respond? Okay. All right, so let's turn to a related subject, and this will be for Darren, and then for Joanna, and then others if they would like to. And this is the question of what Amex might tell us about the treatment of efficiencies in antitrust doctrine, or the economic analysis that underlies it. So we ordinarily take the view, when we're out there engaged in the antitrust thing, that efficiencies in one market, pro-competitive benefits in one market, shouldn't offset, aren't adequate or relevant to offset harms to competition in another. Now, in Amex itself, that issue wasn't presented because the court defined a single market in which both merchants and cardholders were purchasers. But let's set that aside and let's focus on multi-sided platforms that really are selling into different markets. I don't know, some maybe social networking on the one side, online advertising on the other, for example. In contexts that are multi-sided in that way, where you have two relevant antitrust markets or even more potentially, should courts weigh efficiencies in one market against harms in another? And if so, is it because of the two-sided nature of the platform, or is it just because that would be better economics and we should be doing that throughout antitrust law anyway? And let's start with Darren.
Sure. So you mentioned the principle that you should not use efficiencies in one market to offset concerns in another. That, of course, refers to Philadelphia National Bank, which, just as an aside, is a holding I've always been sort of dubious of. But putting that aside, I don't really read Amex or really sound economics as saying, whether the market at issue is transactional in nature really should answer that question. As long as the market is multi-sided and there are sufficient externalities between the different groups of participants, I think courts and agencies should consider the harms and benefits to all sides of the platform, regardless, again, of whether you would characterize it as a transactional platform or not. Only then will the reviewer be able to correctly determine whether the conduct at issue is anti-competitive. I mentioned this in my opening comments. I don't read Amex as being limited to transaction platforms. I think it would have been odd to read the decision in that way, given the many sites I think we were talking about before, to the economic literature, which of course is much broader in terms of the way it characterizes two-sided markets.
Joanna.
So I understand, from my antitrust lawyer friends and people I've worked with, that we do not consider out-of-market efficiencies in antitrust analysis. So as a simple example, suppose a retail merger benefits consumers in one state but harms consumers in another state. The two effects are not combined to say the effect is zero. That's the state of things. So what is different about multi-sided markets that would warrant different treatment? Perhaps in some markets we have, and this is just a proposition, but perhaps in some markets we have end user consumers on one side and providers on another side. Say travel website with rental car, hotel, flights, providers on the other side, and then consumers on the other side. And if the merger resulted in efficiencies on the provider side, arguably with some pass-through, okay, if one were to recognize pass-through of lower costs, they may lower prices to end users. And some harm on the end user side may be countered, okay? But it would need to be thought through very carefully, obviously, just like in antitrust analysis, we always think through efficiencies very carefully. What are the circumstances and what are the examples of, as an example of a merger that would result harm to one side and really efficiencies to the other side?
Thank you. Would anyone else like to respond on the treatment of efficiencies?
Yeah,
Tasnim.
I think that this is where multi-sided markets, I think, is different and tougher in so many ways than merger work, because if, you were presented with the merger example you gave, that in one geographic market, no problem, in another geographic market, there's some concern, we could talk about a divestiture plan and try to retain the good and jettison the not so good. But it's quite possible that, again, it's fact-specific, and I don't have a specific example in mind, but it's quite possible that certain mergers or certain types of conduct with multi-sided markets only work because they're intrinsically making the platform bigger. And so I don't know that a remedy would be nearly as convenient or even feasible in that context.
Well, so it's inherent in many two-sided business models that companies make trade-offs between the interests of one set of consumers and another set of consumers. And so just consider a television network. Suppose it does something that it increases the number of ads that it shows in ways that irritate the viewers. Is that if they haven't if they're not broadcasting what the viewers most want, could that be the exercise of market power or an antitrust violation? Well, it's inherent in the business model that that you have to show the ads even if consumers don't like them. So I think that is a complication that you don't see in some one-sided markets.
Yeah, I would just say this is one of those areas where you asked before, like, are you concerned about the possible misuse? I think price fixers like to say that they can save jobs in their industry or whatever by fixing prices. There's always the chance that you can redirect the rents that you extract on one side of a market to another side of your platform or business model or the like. And so you just want to be extraordinarily careful about permitting that kind of analysis because it leads to bad things. And, in general, this is the thing that we're supposed to be trusting to the markets. That is, we try to set up a well-functioning game, and then we let where the benefits and costs flow according to competition, and not from judges trying to say, well, it's true Bob got really hurt, but Joe seems better off, and using incommensurate prices or whatever, we'll try to balance that out. So, I think in general, that's a dangerous direction, so it's better if it's as limited as possible. And, I think, but you will see companies argue, well, we're a two-sided business, and there are benefits from this anti-competitive behavior somewhere else in our business, and so all should be good.
All right, I'd like now to introduce some of the questions that we've had from the audience. And I'm going to start with the first one we received. So the question is, can you talk about the inherent conflicts of interest found when platforms operate multi-sided markets? Often platforms directly compete with those also competing on their own platforms. So I read this as a question about essentially vertical integration, right? We often find ourselves in a situation where a platform is effectively integrated in a way that puts it into competition with its customers on one side of the market. For example, if I was running an online retail website where merchants or manufacturers offered their products through to consumers, I might, in addition, have a merchant or a manufacturing business in which I was in competition on one side with some of my own merchant customers. And so the question, I think, would be how, if at all, should that fact of vertical integration on one side, change the analysis of market definition or market power? And this I throw open to the whole panel.
Well, I'll just start with a concrete example because it's probably easier to wrap our heads around one. Take Amazon, right? Amazon is a marketplace. It functions as a marketplace. It has lots of third-party sellers. It's for buyers and sellers to find each other in large part. It's also a gigantic retailer and sells a lot of stuff. Is there a potential conflict of interest there? Sure. Of course there is. Amex is a profit-maximizing entity. It's probably interested in doing whatever it makes the most money doing. How do we figure out if there's a potential problem here? We would do it probably by starting with an analysis of whether market power exists. That is, the sellers who offer things across Amazon, and look, I'm going to do this in a way that isn't particularly two-sided because I'm just attending to the question I'm trying to answer, right? The competitive constraint on Amazon monkeying around. What we're concerned about is Amazon monkeying with the people who sell things on the Amazon platform. And the constraint on Amazon doing that is those sellers being able to take their business elsewhere. And so we just ask a really straightforward question. Are people who sell through Amazon able to do otherwise? Can they find other outlets for their businesses? And you can interview them and find out if they feel comfortable not offering for sale through Amazon, even though Amazon is monkeying with them, for example. And you can see what are the alternatives to Amazon? How else can they offer their products? Someone was up here on the last panel saying how the ability to market through these marketplaces has actually allowed a lot of people to come to market who couldn't have otherwise. Well, that's great. That is a good thing in the world, but it's also evidence that they need these markets in order to operate, and they may be at their mercy. So I think you have that conflict that the questioner identifies exists. It doesn't require special multi-sided analysis to figure out, I think, what it is we care about.
I guess one thing I would add, I think Eric's example of Amazon and third-party sellers is a good one. I think that illustrates, pretty effectively that for most types of multi-sided platform markets, the platforms compete not only against other platforms, but also sometimes against more traditional sellers. So in the Amazon example, some of the other sellers on this platform are, more traditional sellers. They're not themselves necessarily platforms, as well as Amazon also competes against traditional brick-and-mortar retailers, such as a Walmart. So I think it's important to not only consider, going back to, Michael's comments from the very beginning, not only to look at other companies that look similar to whatever company is under scrutiny, but to look a little bit further at not only at other platforms, but other companies that are offering very different business models, because they may offer a constraining effect on the company at issue.
So I think this is, in essence, the very traditional economic antitrust question of leverage. And And, if I control a platform, do I feel tempted to take over one of the complementary sectors in a way that gets me money and makes my customers worse off? And I think if David were here, he would probably say, no, then you wouldn't be being a platform, because being a platform is about appealing to all sides. And I think the hardcore economics that perhaps echoes that is, of course, there's a downside to a platform sponsor in turning one of its sides into a chore rather than a pleasure. Whether that downside is heavy enough to outweigh the upside turns out to be a fairly detailed and nuanced analysis. It's something that's been analyzed in a fair amount of detail in the aftermarkets context, which is one illustration. We don't tend to think of an aftermarket as a platform, but it sort of is. The one monopoly rent theorem is about that, and the main thing to remember about the one monopoly rent theorem is it's a very important observation, but it's not a theorem.
All right, I'd like to turn now to the second of the questions I have here from the audience. And the question here is...
I'm sorry, can I answer that?
Oh,
last
please,
question?
Michael, yeah, for sure.
So the Amazon case is an interesting case because, of course, Amazon started out as a one-sided business. It was a traditional retailer, right? It wasn't a brick and mortars business, but it was buying books and then it was selling them. Of course, it was so efficient that it then opened up its platform to other sellers. And so, does it matter which direction this went? If they'd started out as a platform and then moved into their own selling, would that have changed the analysis? I hate to keep coming back to Google, but this was precisely the issue in the FTC's investigation into Google, and has been the issue with respect to the European investigation into Google. And if you say, look, the Google is somehow leveraging its position as a general search engine into thematic search, then you're completely misunderstanding the nature of the product. The problem a general search engine faces is that different searches, you can have the identical search with much different intent. And so if you're a thematic search engine, if you go to Expedia knows you're doing a travel search. But if I, sitting in Boston, entered Washington, D.C. into Google, they wouldn't know that I was doing a travel search as opposed to being an 8th grader doing my social studies project. So the way a general search engine works is it runs multiple thematic searches simultaneously, and then has some sort of meta algorithm to determine what the search was likely to be, and there are often different possibilities. And so then when you do a particular search into Google, you're getting their search results. And when people are saying, well, these different pieces of Google are those are separate products that Google is somehow leveraging its market power into, but they're not separate products, they're a single product. And so these there are often these assertions of vertical foreclosure that I think are misplaced.
Before we finish the detour onto vertical integration, Joanna, Darren, Tasnim, any further comments?
Not for me.
Okay. So the next question from the audience that I have here is this. How can plaintiffs and prosecutors disprove efficiencies in the affirmative case? So one of the things that Amex tells us, or at least very strongly implies, is that a showing of prima facie anti-competitive effects under the rule of reason requires a plaintiff to evaluate in that context not just benefits, not just sort of harms to merchants, but also and simultaneously benefits to cardholders. Or at least that's one way of reading the decision. So on one view at least, Amex implies that just to get off the mark in a rule of reason case, in a two-sided market, particularly in a transactional context, a plaintiff, whether it's a government plaintiff or a private plaintiff, not only needs to prove some harm, but also needs to engage affirmatively with any evidence of benefit, whether in the form of lower prices for some customers or increased quality. As a practical matter, how significant do you think that burden should be, and how do you think plaintiffs should go about engaging with it, recognizing that it looks like an increase in the barrier that a plaintiff has to get over at the beginning of the rule of reason analysis? And again, this is to anyone on the panel who'd like it.
So I guess I would dispute the premise of the question. To establish a prima facie case under Amex, one thing a plaintiff could do after properly defining the market is to show output had declined due to the restraint, for example. In that case, there's no weighing of benefits versus losses. We have a drop in output. Likewise, you could show a decline in quality of services across the two sides. That would also be potentially sufficient. I think it's only where you get into a pricing effect is perhaps where maybe this question is really aimed, of looking at potentially higher prices on one side versus lower prices on the other. And in that case, I think if that was your case, if you're bringing a direct effects evidence case based on prices, which is not how you'd have to bring one of these cases, in that case, you would have to look at both sides and show the net effect on prices across the two sides, which obviously is going to be challenging.
Thanks, Darren. Anyone else? All right. Then the third of the questions I've received from the floor is a specific one about health insurance. And so the question is, are health insurers two-sided markets under Amex? And if so, does that affect how a court should define the market in an insurance merger? So this is an open question.
I'm going to take the second part of the question first, because it's really useful. Because the first part of the question is too inchoate to answer, right? Like, without knowing why you care about health insurers, I can't really tell you if they're two-sided or three-sided or eight-sided or 12-sided die. But when you say, well, I'm worried about a health insurance merger, then I think their quote-unquote two-sidedness becomes kind of straightforward. If you take the ordinary consumer welfare standard, where the purchasers of health insurance are our primary concern, you would say, well, no, this isn't two-sided at all. I'm curious whether the price of health insurance to people who purchase it will go up, and the increased power that, market power that this entity might have over doctors or hospitals in the area, say, will now present as a good thing rather than a bad thing, because it will allow it to negotiate for lower prices. Now, I mean, you can quarrel with whether that consumer welfare model is the best in the end and whether we should be concerned with buyer power in those markets or the like. But, I think it resolves away concerns about its two-sidedness when you see it through the lens of the antitrust question that you're trying to answer.
Thank you. I've just received another question from the floor, which I think, well, let's put it this way. So, can a platform firm have market power on one side and be in perfect competition on the other? I think the answer may be no, but let's put it to a member of our panel.
I'm sorry, can you repeat that question again?
For sure. The question is, can a platform firm have market power on one side and be in perfect competition on the other?
So I think, let me rephrase the question. Part A, can a firm have market power, let's say an output, and be a price taker on its inputs? Of course. In fact, that's the standard way we measure, that we model a firm with market power. So I think the only sensible version of the question, which is would have to be, if we're thinking about a firm like that, would we not call it a platform firm?
Right.
And so I think that becomes a question of definition, and I think not very interesting.
So, I hope so. I will just say, taking credit cards as an example is a really interesting way of looking at this question, right? One of the striking things about credit card markets is that the credit card companies have a very, very narrow set of competitors on the merchant side. There are basically 4 credit cards that you can agree to accept that are useful. Amex, Visa, MasterCard, and Discover. Discover has a very small share of the market. On the cardholder side, Visa, MasterCard, and American Express. Actually, Visa and MasterCard aren't even themselves properly understood to be the competitors, because you can pick as a cardholder among all of the banks that offer credit cards. You can get a credit card from Chase, Capital One, your local credit union. It's tens of thousands of competitors. And this is one very straightforward way of understanding why things are really good in this market for card members and not so good in this market for merchants, right? Merchants have to pick among 3 card companies that have a lot of market power. And card members get to pick among a huge number of competitors who are viciously fighting with each other for card holders, mostly so that they can get the rents available on
Wait,
the
aren't
merchant
there a
side.
lot of acquirers too?
Well, it's more complicated, I guess, than I'm saying.
Yeah, I think it is.
But you can see, I think, why you can have a different set of competitors on both sides of your business model, which I think is all I'm trying to get at. You can't really look at a platform firm and say, well, they're going to have, because you're not looking at, this is what Michael was saying, you're not looking for people who have the same business model. That's not how you identify whether you have a competitive market or not. You could have a different set of competitors on one side and the other. And that's very true in the credit card context in particular.
Would anyone like to respond? All right, then we've talked quite a lot about conduct and conduct implications, particularly sort of vertical agreements. One thing we haven't talked very much about is merger cases. So let me ask this first to Tasnim and then to anyone else. In your view, does Amex have anything to teach us in merger cases beyond the kind of things we've talked about here? And if so, what do you think it is?
So I think that in many ways the answer is no, because it comes back to the primitives. I think that what we've been talking about are things about really understanding the competitive forces that discipline firms. And whether it's in a single-sided or multi-sided context, I think we just have to do the hard work and understand the facts and understand the competitive dynamics. So in many ways, I would say no. I think that the fact of the American Express decision has inevitably heightened awareness on transactions that involve multiple sides, and I think we're all going to have to do some mindfulness to make sure we don't trigger either the buzzwords or the buzz principles, what have you. So in many ways, substantively no, but I do think this will make us more cautious going forward. And then lastly, on the issue of efficiencies, I've already said a little bit about this, but I don't think American Express, at least the fact pattern in American Express helps us think hard about efficiencies. It doesn't. It doesn't give us a roadmap. So at most, I hope that it doesn't get misused to suggest that we can offset, a harm to one consumer group because of benefits to another consumer group. If that happens, it would have to be because of a very stylized set of facts.
Anyone else on the topic of mergers? All right, well, I know we have just a couple of minutes left, so I'm going to ask a final question, and then anyone who'd like to do so would be welcome to add any closing remarks or a couple of sentences just to wrap things up. So the final question I have, and we'll start with Eric and Darren, is about the meaning of the Amex decision for antitrust law, sort of more generally. So we know that the meaning of a Supreme Court case, of any important precedent, really isn't so much to do with the text of the decision. It's really a function of how it's used and how it comes to be understood in the period that follows. So my question is whether Amex will come to stand for a broad proposition or a narrow one. So on the narrow view, right, Amex could be read to suggest that in its least controversial form, if you as a plaintiff show only an increase in nominal price to a subset of purchasers in a relevant market, you have not cleared the hurdle of showing a prima facie case of anti-competitive effects. That does not seem controversial. That does not even seem specific to two-sided markets. On a much broader view, Amex might suggest that in cases where intermarket externalities are significant, cases of multi-sided platforms, whether it's one relevant market or two or even three, a plaintiff has to show an overall loss of output considering all sides of the platform at once in order to clear that first hurdle. So my question is, which of those two readings, the broad or the narrow, do you think is more appealing, and which do you think Amex will come to symbolize? And why don't we start with Darren?
Sure. So I think I touched on this in my opening comments, so I'll be sort of brief and just say I think the reading of the case is unmistakable that in a two-sided market, establishing harm to just one group of participants, is not enough for a plaintiff to make a prima facie case. I think that's a very straightforward reading of the case. I think the narrow reading that you put forward is just not consistent with the plain language of the decision. Let me also just sort of make one other quick point, which is that the Amex decision really didn't come out of nowhere. There actually were prior cases, significant antitrust cases that announced similar principles. Joe actually touched on one of these before, though he didn't mention the name, which is the Eastman Kodak case from '92. This was the aftermarkets case. And in that case, the court said, if there had been evidence that equipment sales disciplined aftermarkets, it would have been appropriate to define a single market for the original equipment sales and the aftermarkets, and that plaintiffs would have had to show harm in that overall systems market. Another case, US v. Microsoft, DC Circuit decision. The DC Circuit found the applications barrier to entry existed because consumers wanted to buy operating systems that had lots of applications. Developers wanted to develop only on operating systems that had lots of users. Called that the applications barrier to entry. Another way of saying two-sided market with indirect network effects. In the same case, the court defined a single market for operating systems. It could have defined a market for operating systems licensed to end users, operating systems made available for developers, operating systems made available for peripheral makers. Since it was a multi-sided market, it didn't do that. It defined a single market for operating systems. I think this is a good example of how incorporating multi-sided market analysis into decisions could actually strengthen antitrust enforcement, not weaken it. There's lots of other cases. I won't go through them. If you go back in the last 10 years, there are probably half a dozen or more district court cases that have wrestled with multi-sided markets and indirect network effects. Courts have not really struggled, as far as I can tell, with managing with these concepts. You might quibble with whether they got these decisions right or wrong. But the fact is, lower courts are actually addressing these issues on a regular basis, and so far don't seem to be having to devote an excessive amount of effort to do that.
Thank you.
So,
Eric.
I mean, I've already revealed myself as an Amex skeptic, so I guess I should say I hope that the application of it is narrow in some respects. But I will say also that I don't disagree with Darren, that there's a way that Amex can be applied that is consistent with things that courts have already been doing, which is in a generic kind of way, considering indirect network effects and other things that discipline one side of the market through the other side of the market as relevant to either establishing a prima facie case or a defense that you don't in fact have market power. If it's applied in that way, it will do minimal damage. I think the thing that we ought to be concerned about is this sort of on-off switch where a defendant tries to show that they're a two-sided market, and having flipped the two-sided market switch, then has available to it a bunch of defenses that make it essentially impossible for a government regulator or a plaintiff to prevail. If that latter thing happens, that's an unfortunate use of the decision. It will sow a lot of mischief in the law, and unfortunately, I think, for the reasons I said at the very beginning, that's as likely an outcome, I think, as the more, what I'll say, narrow one that Darren describes. Although it might be a broader use of the decision, it would be one that's much more constrained to ordinary antitrust doctrine, and that would be good.
Thank you, Eric. Any final reactions from our panel members? All right, well, it's 1 minute past 5. I think it's been a terrific discussion. Thank you so much to our very distinguished panel. Thank you for your attention and your questions. It's the end of the panel, it's the end of the day, and I wish you a good evening.
January. So it's been a few months. Yeah. How are things?
Hey, Doug, good to see you. How are you doing?